The juror today who had expressed in very emotional terms his feelings about the American role in the Second World War, where he served. And I think, our dropping of these bombs, good old Harry Truman's decision to do so, had saved him 3 or 4 months of service in the Army. So this man is pounding his fist and say, I was there in the service when those bombs were dropped. And it was the right thing. And I believe it was the right thing. And how is he going to sit as a fair juror on these people who today say that we have this power of overkill and who say that we shouldn't have these weapons that can destroy humanity?
The real problem is the judge limiting our access to this type of information. If we can't ask the question, we can't find the fact out, and we therefore can't act on it. No one is, at this point, judging that individual jury. That's not our purpose in being here. But we need to find out certain facts about their attitudes and their preconditioning that would prevent them, effectively, from being fair in this case. And the judge is precluding us from doing that.
As you're saying, he's limiting the questions that you can use to find out whether the prospective jurors have an open mind.
Yes, right. We met with him early on for the purpose of reviewing questions that would be asked. He gave us 15 minutes to produce questions for him. We discussed the questions that would be asked. Some he refused, including the questions about Hiroshima and Nagasaki. Other questions he permitted. By the end of court day, he had come up with a typewritten list of questions, which he claimed were represented our agreement with respect to questioning, which was not true. They represented his questions, the way he phrased each question. Every time there was any movement from the script, he would come down very hard on the defendants, who finally elicited from him the agreement that they would be given some latitude in questioning, some latitude in asking follow-up questions. In spite of that understanding, he would continue to limit them, ignoring his prior rulings. Now the judge has taken over questioning himself completely, and the defendants are only permitted to write out questions which he asks at the end, out of context, not at the time that the prospective juror might make a statement that deserves follow-up. It has to be done at the end, only after the judge rules which questions he'll ask and which ones he won't, of the ones we submit.
And I think it would give you an understanding of how bad the process has gone since he started it today. We all wrote out questions. I would say there were at least 100, maybe 120 questions. He read 4. And they were 4 general questions. They didn't go to any of the essential elements of what we need to do. One of my questions would have been, do you as a juror think you have the ability to understand a defense of justification if I explain to you, and then explain what it means under Pennsylvania law? And can you accept that? Because there are jurors who cannot accept that. They cannot accept that you can trespass on somebody's property and destroy it if it's part of the war machine of this country. They would not find that acceptable. And I think to ask after only 3 or 4 questions, if I, with my robes and with all my authority looking down upon you, tell you that you are to follow my instruction, would you do that faithfully and fairly and all that nonsense? And, oh, yes, Judge, of course. Well, that's not human beings responding to anything. It's like a child saying, I'm not going to get slapped, am I, if I do what you tell me?
You have to understand these jurors being brought in here are probably, most of them, entering a courtroom for the first time. They walk into a courtroom which is very formal with a gallery of press. The district attorney sits right in front of them. The court sits there with a robe. We sit there, 3 advisory counsel and 8 defendants. Everyone looking at them, trying to assess what we can see just physically. They walk into that environment, and they are obviously at ease. And then this judge asks them, if he tells them something is the law and they must do it, will they do it? I can't imagine them saying, Judge, no, because if my conscience said that was incorrect, I would have to follow my conscience. Or I could, but the fact that I work for General Electric, I've got to go back to my place of employment and answer to my co-employees for a not guilty verdict. Or the district attorney of Montgomery County is one of my clients. I work on his car. If I, acquit, I have in the back of my mind, am I going to lose his? All these things have to be probed, and to prevent the defense from doing that, they might as well just bring in the first 12 jurors and sit them down and start, because that's effectively what they're doing.
The purpose of this whole process is to get a fair jury. And to get a fair jury, you need to know something about the people who are coming in the room. And the little questionnaire that they filled out tells you whether or not they're married, what their job is, and whether they had prior jury service, and what age they are, and whether they have children. And that's about it. That's nothing. So you need to find out, and some put GE. I mean, statistically, it has been incredible the number of GE employees we've gotten. And they have not been challenged for cause. This judge has no intention of excusing somebody just because they work for GE.
Or other defense contractors.
Or other defense, you know, Sperry Univac or anybody else. They're not going to be excused, even though the developments in this trial are going to be that these defendants oppose the entire war machine.
Do you have any idea how this judge became the judge for this trial?
I think he was among the 3 judges available. I think that although he is considered, quite frankly, the worst judge out of 15 in this community, and apparently was among the worst public defenders that this community ever had before he became a judge, that his availability, unfortunately, was timely. In other words, he happened to be on criminal duty at the time that this case came to trial, and he had just finished another case. I don't think it was conspiracy. I don't think we're paranoid about everything about the case. I think we've had some bad luck. I think getting this judge is the highest level of bad luck, because he has no judicial temperament whatsoever.
Is it possible that this bad luck might turn out to be good luck?
Oh, of course. I think good lawyers more than defendants, because I'm always thinking of the appeal, and I'm concerned much more than the defendants are about their going to prison, because when a client of mine goes to prison, I go with him. My soul is with him, and a piece of me is with him. And for these good people to go to prison would be anguish to me, as it was for the 5 months when they were there. But with this judge, the opportunity of making error is rampant. It's happening every 5 minutes, and I expect that during the trial we will have endless error. But that's not the mission of these defendants. They want a fair jury, they want a fair trial, they want to be able to broadcast their message, and they want to be able to speak to good human beings, including a good judge, so that they might convert them.
It's an experience for them. It's an experience, just as the action was an experience, a witness. They are giving witness to this the nuclear proliferation by being in this courtroom. They want to dialogue not only with the jury but with spectators, with the judge. They would like this to be a dialogue, and in this particular, so far, I don't think there's been much dialogue. They've been prevented from effectively communicating.
Well, the dialogue would probably be along the lines of justification and principles of international law that you've been talking about. Could you explain in more detail what justification means and how international law is applicable in this case?
Well, of course, we hope we'll have a chance to develop that really thoroughly. But, I mean, just taking the Pennsylvania statute, on justification, without holding me to the quotation of it, but my understanding of our statute, Section 503, I think it is, says that in the criminal code, that if your conduct is such that it prevents a greater harm to you or to someone else, a greater evil, even it uses the word evil, that would exonerate you from culpability. So that actually what you've done is not a crime. I mean, it's not even that we're conceding we committed a crime. It's that you are justified in doing what you've done. It's very easy in common life to understand this kind of thing. It's not so easy to understand it in terms of the context of this case, because we're not used to doing that. It's like, what is the immediate harm, and what are we preserving here? And to laymen, I think it'll be difficult unless they have a judge who allows us to explore that. And under international law and the concept of the responsibility to the international community and the treaties of this country that we have entered into, and our participation in the United Nations, and the requirements that we have agreed to non-proliferation, and the fact that we continue to produce offensive weapons. This is an offensive weapon.
I think, a very appropriate example that would demonstrate justification, and one that the defendants have attempted to express, is the responsibility of, for example, a citizen in Germany to enter death camps to destroy ovens. That may have been a violation of German civil law, but those citizens would have been, had they done it, justified by reason of the fact that their act was to prevent this atrocity of the Holocaust. That is the scale of what these defendants did. That is the type of example that has to be expressed to this jury. They're talking about genocide in this case. Justification at the highest level. And the Nuremberg principles must be applied in Montgomery County. It's just that simple.
Have they ever been applied in a political case of this kind in this country?
Yes, it's my understanding that the principles of justification, including the Nuremberg principles, aspects of the United Nations Charter and other treaties which the defendants will cite, have been applied in other cases. Specifically, I believe in a case in Colorado.
They certainly have been allowed to be introduced, and I think that's really where we begin, because I think to these defendants, it matters not whether they're convicted or not. It matters only that the world hear what they did and why they did it, and their sense of responsibility about doing it, and their active conscience. And I think that their hope is that other people will feel that they too have an obligation to act out of conscience.
Speaking of that, can you maybe comment about the exclusion of the media from the courtroom itself?
Well, for this particular trial, a motion has been made because there's been a recent finding by the Supreme Court that a defendant may not object to being televised. And in this case, separate counsel has made a request that the proceedings be televised, if that's what you're referring to, or videotape, broadcast. And it seems to me there's no trial more appropriate for that, because the defendants not only do not object, they request it. And there would be no disruption. The motion is on its way to the Pennsylvania Supreme Court, and I'm reasonably hopeful that the court will, well, I know they will take it seriously, but I'm hopeful that they will act affirmatively on it.
I didn't, my ignorance again is stupendous, but I didn't realize that the judge could take the power to say, no, you can't have video cameras.
Well, he has the power, certainly, to say no, basically because there is a Pennsylvania rule of court that says that there is no, recording device, no television, no broadcasting. Whether it extends to videotape or not is an interpretation of that rule. And every judge has a right to decide that something would upset the decorum of his courtroom. So initially he can decide that. But really this judge has taken the position that it's not allowed in Pennsylvania. So I think that because of the rule of court, the safest course is to engage the minds of the Pennsylvania Supreme Court and ask them, as is being done formally, to withdraw that rule and allow the public in every way, not just the print media who can sit there and take notes, or if you happen to be an artist, you can draw a picture, but take an actual photograph and take an actual recording and get the tone of what's being said, because I think even a transcript of a trial never conveys a trial's course.
I think we would have been, we were surprised, I think, that the request for this, the videotaping of these proceedings was made by independent film producers.
As opposed
Mr.
to
D'Antonio
major
from New York, but the major networks didn't pursue it to the extent that I thought they should. It's an important issue. I thought that it's something they should be interested in. Local television stations, I think they should have sent personnel to speak and to take similar petitions to the Supreme Court, because I think this is an ideal case for it. The defendants in this case do not oppose it. It's a case of significance, and it, I think, is a forum that should test this ruling.
Well, there might be some discussion about who's actually in charge in terms of the networks, in terms of their own political stance, and how they are corporations themselves.
I'm sure that's significant. Sure. Yeah.
But I think that they're missing an opportunity that if they ever do want to cover a trial, they'd better start fighting for that right now. And this seemed like an appropriate time to start the fight because the Supreme Court of the United States just made its recent ruling in a Florida case. But in any event, that may be decided before we get underway. We're still in jury selection.
One final question. Maybe you could comment on the fact that Molly Rush's children have been excluded, like where they seem somewhat outrageous.
Maybe I could speak to that because I raised it today with the president judge of the Court of Common Pleas of Montgomery County. He is the senior, not senior in terms of age, but the chief judge of this state court. Judge Salas, the trial judge, originally stated that he would not prevent Molly Rush's two young children, one 14 and one 12, from entering the courtroom during the proceedings, in spite of the fact that Molly advised the court that she engaged in this action and was participating in this trial for her children. Her witness in this action was for her children, and she thought and requested that they be there to participate in it with her, to observe it. The court, Judge Salas, advised Mrs. Rush that there was a court policy that no children under 18 would be permitted in the courtroom. The judge was reminded that school students, young students, are brought into the courtroom frequently to observe proceedings for educational purposes. He said that these were exceptions and they weren't, these students weren't brought in for the entire proceedings, and anyway, there was this policy. We went before Judge Lau this morning, and I advised him that Judge Salas had stated that there was a court policy against it, and if that were true, that he, as president judge, could perhaps modify that policy for this case. Judge Lau said that there was no such court policy that he was aware of, but that it was left to the individual discretion of the trial judge. This fact was again raised with Judge Salas, and he again refused to permit Mrs. Rush's two children from being here, in spite of being advised that Mr. Rush, Molly's husband, would be with the children at all times, as well as her other four children who are above 18 and who hopefully will be permitted into the courtroom. But the judge also has limited us to one family member per defendant with the right to enter the courtroom each day. So members of the clergy may be able to choose a member of their family. Those defendants who are married would be able to choose a spouse, but everyone else is first come, first served. He would not reserve appropriate seating of 15 or 20 spaces for the people we requested. So I think it is all consistent with his ability to dehumanize these proceedings. And that's what it is. This is a human process, a human witness, and the judge and the system itself, I think, tends to dehumanize it to the greatest extent possible, and it's tragic.
The only other thing I wanted to ask, Michael, is that you are a local resident, right?
Yes, my law office is directly across the street from the courthouse, and I'm a member of the bar of this court, and I live in the county and the community.
I'm just wondering how you feel about the proceedings as being a local resident, because many of us, I mean, filmmakers and lawyers, and even some of the defendants will at some time be coming and going, while you will remain here.
I think that there's a certain attitude in this county and in other counties that responds very negatively to these type of people of conscience, and I think that will linger here. But I'm hopeful that what they've done in this county will have the effect of raising the consciousness of citizens. So for that reason, I'm glad that it happened here. There may be some after the fact fallout, so to speak, with respect to me personally, but I can't do anything about it. I'm certainly not concerned about it.
He can handle it.
Thank you very much.
Okay.
Glackin.
Mr. Glackin, I understand that you were involved at the very early stage of the proceedings in this
Yeah, I was.
case, and that you even appeared at the GE plant.
That's right.
Can you tell us what happened then?
Can you explain that?
Yeah, I think we had some of that in the beginning. Yeah, essentially going back to the plant and seeing the damage and
If it's
all
only
of
on
that.
tape, that's fine. Thanks very much.
Okay. Good. You okay?
Yeah, ready?